Hello, everybody. Welcome to my live and happy Friday. Weekend's almost here. All right, so what are we going to talk about today? Well, I'd like to talk about the B2 visitor visa, but specifically about the invitation letter, what that means, how it's done, when it's asked for, what's supposed to be in it, things like that. And then after I'm done with my little spiel, I will look and see what questions you guys have on immigration law. I will then answer it, and then after that, go to my consultations. Okay. So, let's get started. First of all, a B2 visitor visa is exactly what it says. Okay, it is a visa that allows you to come to the U.S. and visit. The reason I want to talk a bit about the invitation letter is I received a request the other day from some guy in a different country. I can't remember which country. I think it was Pakistan. And he said, "Can you please write me an invitation letter from your law firm so I can come into the U.S.?" And minus the fact that, my law firm just doesn't do that. We just don't issue blanket invitation letters. Even if we did, it wouldn't mean anything because you can't have some blanket invitation letter to some guy you don't know and some reason you're not sure why he's coming. Okay? I mean, this guy from Pakistan literally thought that I could take on my firm letterhead and say, "I am inviting so-and-so to the U.S." and that would suffice. And that's not the case. It doesn't work like that. Number one, it's a little bit fraudulent in that I'm really not inviting somebody because I want to invite them for some specific reason for me. Okay? So this guy thought that in order to get the B2 visa, he had to have an invitation letter period, regardless of whether or not he knew that lawyer or that law firm. And the reality is if he wants an invitation letter, he needs to get one for the person or company he's coming to visit, not from some unassociated law firm or from an attorney he does not know. It just doesn't work like that. It doesn't make sense either. So if he's coming to the U.S. to visit and he cannot get an invitation letter from whoever at the other end, then he really doesn't have the evidence to show that he's been invited. Okay, and he's planning on just coming to the U.S. cold without knowing anybody. Now, I'm not saying that a B2 can't be done in that case. It can. Okay, if somebody in Pakistan wants to come to the U.S. to visit the Statue of Liberty and then go visit the ocean, it's up to them and they can do it. Okay, and you don't need a specific invitation letter. Now, that's not to say that the case will be approved and that it won't be harder, okay, especially from countries that have a retention rate of people violating their visas that are pretty high. So if somebody just decides they want to do that, there's going to have to be a lot of evidence on how they are going to come back to their home country once they're done with the visit. Now, back to the invitation letter. If they have a real invitation letter, not a fake one, or not one that they're paying a law firm to pretend like they're really inviting them, which, by the way, would be an ethical violation anyways. So a law firm who just, gets retained to do some invitation letter without a real invitation, that's not ethical. If they can get a real invitation letter, then it will look better and it will add more credibility to the fact that they are coming to visit for whatever reason. It also adds to the fact that maybe they're going to have someone who will pay their expenses or where they're going to stay, and that they won't need to deal with room or board, things like that. So especially for those countries like Pakistan, that it would be hard to get a visitor visa anyways, if they can get a real invitation letter from a real person that they are visiting, and that person can show why they're coming, how they're coming, how they're going to take care of the expenses, why it's just a visit, and how they're going to go back when they're done, then the chances of approval of the B2 are a lot higher. Okay? The reality is that when you apply for a B2, it depends what country you're coming from as to the probability of success. I always prepare the B2 strongly, the petition, an application for the person. But if I know they're coming from a country that has a higher rate of denials, it needs to be made even stronger. Okay? And of course, a powerful, true, real invitation letter will help and will make it so that they have a higher chance of success. Because the reality is, they think you're going to come to the U.S., stay, and never go back. Okay? Which is all the more reason that this guy from Pakistan that wanted my firm to just do some invitation letter without really inviting him, it's just fraudulent, and it just doesn't look good. Okay? So that's how it goes. So that is the spiel on invitation letters with the B2. Okay? Now, let's go back and see if we have any questions. It is Friday. I know that it's the end of the week and y'all are tired and you want to have a nice weekend, but that doesn't mean you don't have questions. So let's see. Okay. Just scrolling. Okay. So Ramiro Fuentes just got the #1 gifter badge. Oh, thanks, Ramiro. You give me a gift. Okay. That means you're probably going to have a question, right? Because usually those who get the #1, and here we go. See, I knew it. Okay, from Ramiro Fuentes. How long is the wait for an interview in Juarez? Well, you're going to have to be a little more specific. I need to know interview for what? Okay. Are you going to apply for a B2 visitor visa, for a non-immigrant visa? Are you going to apply for an H-1B, O-1, R-1? Are you applying after all the work has been done to become a resident? So it depends. I need to know. So Ramiro, while I'm answering other questions, answer me what you are waiting for and what you applied for in order to go to the interview, so I can give you a better answer. Okay? Because I could tell you more or less for every one, but why do that? You just tell me what more specifically what you got. Okay? All right. This is from Moral, or Morale, or however you want to pronounce it. Oh, great. I was just about to read your question, and it just scrolled up. There we go. Can I use my home country passport to travel to a third country with green card asylum based? Okay. I'm assuming you got the green card based on asylum. True? And I'm assuming that because of that, obviously, you can't travel, by the way, on a green card. That doesn't allow you to leave and come back. You have to have a passport. And the passport obviously has to be from your home country, unless you're a citizen of two different countries, which if that were the case, you wouldn't be getting asylum because you would have gotten citizenship in a third country. So in this particular case, the real question is, you got asylum and you want to know if you can use a passport to go to a third country. And the answer is yes. But that does depend on the immigration policies of that country. So if you are going to a third country, whether you got a green card based on asylum or not is not relevant. Okay. The question is, what does this third country need or require for you to go there? Some countries, depending where you're from, don't require anything, and you get an easy 90 days to go visit. Other countries require you to get a visa, okay? So it depends. Usually I get the question, can you use a passport to go back to the same country in which you got asylum, okay? And the answer is also yes, although it's a little tricky because you don't want to be seen as having lied about your asylum when you just go back to the same country of which you got asylum granted. So there's some issues there. Okay? All right. All right. So Romero answered my question. Okay. You're saying DS-260. That means you're applying. Sorry, I guess I got a hair in my mouth. See, that's what happens when you don't trim your beard right. You're applying for residency, okay, for the green card. So once the National Visa Center is done, okay, and I don't know if your case has gotten to the National Visa Center yet, but once it gets there and it gets transferred to the U.S. consulate, some of it, of course, depends on where, but you're asking about Ciudad Juarez, which happens to be about the third or fourth busiest consulate on the planet. So you're going to wait about a year, give or take, okay, once it reaches there. And that's without any issues, without any grounds of inadmissibility. I mean, are you applying for waivers? Do you have any issues of deportation orders, fraud, crimes, unlawful presence, things like that? Okay, it'll all depend. But once it reaches Ciudad Juarez, I say a year, but sometimes it's sooner. So 6 months to a year, give or take. Okay. Alex Lehman. Okay. I-71 751 was approved based on extreme cruelty. Can I file an N-400, 3 or 5 years? Was married to USC. Well, you need to wait 5 years because the 3-year exception is when you're still married, okay, happily married. So it's good you got the green card, but you need to wait the 5 years. But you don't have to wait from the time the I-751 was approved and you got the 10-year green card. You can count from the time you got your conditional green card 2 years ago. Okay, so that hopefully will make things go a little faster for you. Okay. Okay, let's see. Ba-ba-da. Okay, Monty got the number 3 gifter badge. Okay, this is from George. My EAD is produced. What does that mean to me? I don't know what you mean the EAD is produced. Okay, so therefore I don't know what it means to you. It depends what you're applying for. I suspect you might have been applied for adjustment of status. You might be referring to the fact that the EAD has been approved and it will be sent to you. Okay. It usually takes 3 to 6 months depending on that, but it does depend what you're qualifying for. Okay. Romero, I got married. My wife is fixing my status. I suspect that's the case. Okay. This is called a running question. So I answered it, then you answer a little more, and I give you a little more detail, answer a little more, give you a little more detail. I suspect it's a marriage petition, but the question is whether you're inadmissible on any reason or any basis. Okay, were you in the U.S. unlawfully for any period of time? Did you commit fraud? Do you have an infectious disease? Does your wife make sufficient money to show that you won't become a public charge? Have you previously received a deportation order? Have you been expeditedly removed? I mean, there's lots of things I would need to look at to see if you're inadmissible. But let's say nothing like that's happened, and you're obviously in Mexico, and you've been there forever, and you never had any problems. Well, then you obviously get to the bona fides of the marriage, okay? How long did you know her before you married her? How old is she? How old are you? Does she have any criminal history? Okay, there's various things I would need to do to find out. Okay, let's see. Kevin, why am I talking about Mexico? Well, I'm talking about it because somebody asked a question about the U.S. consulate in Ciudad Juarez is in Mexico. Okay? When you're talking about U.S. immigration law involves all the world. Okay? Meaning that depending where you are will depend on what needs to be done, how it needs to be done, and so forth. Okay? Well, Ramiro, as we continue with your continuation, when you say you're on the wait list, you got your pardon approved for unlawful entry, I would need more information than that. Okay? I mean, there's one thing about unlawful entry, and there's another thing for unlawful presence. Okay? When you entered, obviously you entered EWI, that's entered without inspection. I don't know how long you stayed in the U.S. or if you are still in the U.S. I don't know if you filed a provisional waiver of inadmissibility, which you can remain in the U.S. until it is hopefully approved, and so forth. Okay, so it depends. I suspect that you're saying that your provisional waiver got approved. If it did, then they still have to continue your case, send it to the NVC, and then it needs to go to the consulate. So you still have a ways to wait. All right, Jasmine Flower Girl. What's deferred action for parents with children in the Army? I overstayed my visa. Well, it's not exactly deferred action, okay? If you are applying to adjust status in some manner and the petitioner is in the military, they can apply for a parole in place, meaning that if it's approved, you're basically given the fiction that you entered legally and you're able to adjust status. It's very nice, okay? And thankfully and luckily, that one has not been taken away yet, okay? Alrighty. Let's see. I think I got all the questions. We're coming to the end of the live, but if you have any final questions, let me know. Okay. Cocoa Bean. 120 days have passed since the marriage-based interview. What to do next? Well, Coco, what happened? Did you get anything? Did you get an I-72 which wanted to you to give more information? I mean, after a certain amount of time, you can do a formal inquiry, and then if you have to, writ of mandamus filed against them in federal court if it comes to that. But I need to know, first of all, what issues exist. Did you know each other for years and have 12 kids, or did you know each other for a week and then get married? Are you 25 years age difference? I mean, I have to look. I have to know if there's any information sent by immigration to you as of now. Okay? All right. Well, Jasmine, Flower Girl, you say, I thought that parole in place was only for people that came illegally. What about overstay? No. Parole in place is used when someone does not qualify to adjust status. And the parole in place, if approved, makes it so they do qualify. Sometimes people who come in illegally don't. Sometimes people who overstay, depending on the preference of the petition, do not qualify to adjust status. So it depends on the case. Okay? Melissa. My fiance is in Ukraine. Health problems. I can't travel there. How do I bring him to the U.S.? I assume what you're really saying is that you never met your fiance in person and you want to do a fiance petition. I assume that's what you're saying. You can file a waiver of the personal meeting requirement along with the fiance petition, and it has to be very persuasive. You're saying you have health problems, but you can't just say, I have health problems, I can't go. There needs to be documented proof. There needs to be letters from doctors. There needs to be medical documentation, because otherwise everybody would just say that. Okay, you need to have proof. And there needs to be a letter from a doctor that says you cannot travel because it will do A, B, and C to your health, okay, then you have a better chance at the waiver. Okay. Oh, thank you, Jasmine. Says, I am the sweetest. Thanks for answering the questions. Have a lovely day. You too. Thank you for the compliment. Okay. Let's see. Cocoa Bean. Only court documents shows, but no record shows for criminal background check. What do you think? I don't know what. I know I just answered part of your question, but I'm not sure what this is in reference to. Sorry. So send me a message, or get a consultation. Melissa, 3 strokes and mobility issues, risk for blood clots. Yes, that is what I mean. I'm not saying that's good that you have all that, but that is a very decent reason that you won't be able to travel. Okay, so get proof that you had the 3 strokes and you have mobility issues, and get a letter from a doctor who knows what they're doing, who says that there's a significant risk that you will get blood clots if you travel on the plane and so forth, and then what will happen to you if you get them and you don't have a doctor present, okay? The letter from the doctor is very important, okay? All right. Well, I think that's going to call it for today. Everybody have a good... You're welcome, Melissa. Everybody have a good weekend. And until the next time. Okay, bye.